Dear students, I am Mr. Raj Jahan, lecturer, Department of Law, World University of Bangladesh, and this is my class lecture on the topic of forest and wildlife laws. Wildlife management has long been regulated at the international level. Initially, it was done through a focus on the protection of certain species or on the protection of certain wildlife habitat. Most recently, the focus has shifted to more comprehensive approaches epitomized by the innovative feature of the Convention on Biological Diversity. All of these international legally binding agreements are of key importance for the review and drafting of effective national legislation on sustainable wildlife management, either because they pose limit on the sovereignty of countries in regulating wildlife use and protection, or because they call for the operationalization of a specific principle, method, and process for the management, protection, and use of wildlife. In addition, a recent international agreement to address cross-cutting environmental issues, thus implicitly including wildlife management, requires the state to make a provision for public participation in the design of national laws, and this is the Arahus Convention on Access to Information, Public Participation, and Access to Justice in Environmental Matters. Endangered species legislation involved a specialized legal approach to wildlife management. It focuses exclusively on the identification and restoration of species that have reached critically low population level on the basis of defined criteria and procedures for listing these species and at least two generation mechanism designed to ensure recovery of individual species. Listing criteria and procedure are based on science-based definition of threatened or endangered, both of which imply an assessing of the status of the species and threatened to their continuing survival. The primary mechanism for recovery is the requirement that government agencies and private developers consider listing species in designing and constructing projects and also include adequate protection measures to minimize or mitigate project impact and ensure the species' long-term survival or recovery. The second mechanism is the prohibition of direct or incidental take of the species in question. Take includes the killing of such species by whatever means, not just hunting, as well as action that remove a species from its habitat, destroy critical habitat, or otherwise harm, harass, injure the species. Two major international wildlife agreements are species-based and focus on the immediate protection of certain species for the adoption of lists differentiated according to the degree of threat. These lists usually take the form of appendix of the convention, some of which cover most endangered species for which the use is prohibited, while other cover less endangered species, the use of which is allowed but should be controlled. These appendixes are regularly updated by the parties of the convention. International listing are usually combined with a permit system, thus requiring the enactment of national legislation to its effect. The Convention on International Trade in Endangered Species of Wild Flora and Fauna aim to ensure the international trade in specimens of wild animal and plant does not threaten their survival. This convention therefore protects endangered species by restricting and regulating their international trade, though export permit system. The convention requires the states to adopt legislation that design at least one management authority and scientific authority, prohibits trade in specimen in violation of the convention, penalize such trade, or call for the confiscation of specimen illegal trade and possession. The Convention on Conservation of migratory species and wildlife aim to conserve terrestrial, marine, and avian migratory species throughout their range and thus requiring cooperation among range state host to migratory species regularly crossing international boundaries. This agreement may range legally binding treaties to less formal instruments. Area-based international agreements. Another specific approach in wildlife conservation legislation is that of identifying specific areas that are critical for the survival of certain wildlife species. This legal approach therefore prioritizes the protection of habitat as a special conservation area for wildlife. The main area-based treaty are the Convention on Wetland and the Convention concerning the protection of world cultural and natural heritage. Area-based international obligations are usually implemented at the national level, though the creation of protected areas legislation as well as with the legislation ensuring the prevention or minimization of negative interference in or near this area. It should be recalled that species-based treaty also call on permit to protect endangered wildlife habitat along with other management measurements. According to Ramsar Convention, parties must designate wetland in their territory for inclusion in a list of wetland on international importance and promote their conservation and wise use, for example, by establishing natural reserves. Wetland are defined as area of marsh, plain, water, whether natural, artificial, permanent, temporary, with water that is static or flowing. The concept of wise use does not prohibit or regulate the taking of species for any purpose, but at least such use must not affect the ecological characteristics of wetland. The World Heritage Convention provides for the identification and the conservation of sites of outstanding universal value from a natural and cultural point of view, which are included in the World Heritage List. Natural habitat may include areas which constitute the habitat of threatened species of animal of outstanding universal value from a point of view of scientific and conservation. In the framework of the ecosystem approach, the parties to the CBD had further adopted specific principle and operational guideline on sustainable use. Above a principle and the guideline for sustainable, which provide guidance to ensure that the use of components of biodiversity will not lead to a strong long-term decline of biological diversity. The Addis Ababa principle and the guideline has been drafted with a view to generating incentive for the conservation and restoration of biodiversity because of the social, cultural, economic benefit that people derive from it and are also considered as applying to both conservative and compulsive non-compulsive use of biodiversity. Although not legally binding, these guidelines comprise several elements that may inspire national legislature in regulating the use of wildlife to ensure its sustainability, though the operationalization of these elements will require a flexible and adaptable legal and policy framework adjustable to local realities and specific ecosystem. Moreover, underline the need to resolve any overlap, omission, contradiction in existing law and policy and highlights the benefit of creating cooperative and supportive linkage between all levels of governance in order to avoid duplication of efforts or inconsistency.